Good afternoon, Ms. Mahlangu.
Good afternoon, Justice Maya.
I'm sorry we kept you waiting. I do apologize most profusely.
Yeah. It was not longer than I thought. I thought it was going to be longer than this.
Yeah, all right.
So, yes.
You hold 2 law degrees, a BUris and an LLB, both acquired from the Vista University in 1997 and 2001, is that right?
Correct, Justice Maya.
Which Vista University?
Come again, Justice?
Which Vista University?
The Mamelodi one.
Oh, I see.
Yes.
You started your legal career as a prosecutor in 1999,
Correct, Justice
and you
Maya.
remained there until 2003, I see.
Yes, Justice Maya.
Then you became you got a promotion, you became a state advocate,
Yes, Justice Maya.
which you did until 2006. And then you went further up the ranks of that institution, became a senior state advocate until 2012.
Correct, Justice Maya. And then in the midst of everything, I also acted as a deputy director for the asset forfeiture unit.
When was that? During that period?
Yes, between 2010, I think, and 2012 early. Yes.
You decided to join the bar, and you joined the Johannesburg bar.
Yeah, I correct, Justice.
But you
Maya.
had been admitted in 2002 already, though.
Yes, yes.
Right. How long were you with the Joburg bar?
This is my 11th year.
Oh, I see. It says here you joined the Polokwane Society of Advocates. Is that an associate arrangement?
Yes, in 2014-15, when it was formed, the Polokwane Bar, yes, I joined them.
Okay. You have acted as a judge a few times in the Northwest Division.
Yeah, correct, Justice Maya.
You started in July 2020, and your last acting stint was in October last year, right?
Correct, Justice Maya, yes.
So how long were these stints in all? What is the total period?
It was 1 term in 2020, 2 terms 2021, and 3 terms in 2022. And then I acted 1 term this year at the Free State Division.
When, in 2023?
2023, yes.
Is that where you are now?
Yes, I'm still there. The first term and this term also.
Oh, I see.
Yes.
All right. And I see from your application form that you sat in all the courts.
Yes.
The whole gamut. But I don't see, there are criminal appeals. Have you sat in civil appeals?
Yes, I did sit in civil appeals also.
All right. Have you written any judgments?
I did, Justice Maya.
Can you tell us how many?
I think there can be more than 90, Justice Maya. Yes.
90?
Yes.
Any of them reported?
None of them has been reported. Judicial does not exist. It's just Safely.
All right. Do you have any part-head matters at this stage? I see you listed quite a few when you completed the form. Are
Yes,
they outstanding?
Yes, Justice Maya. I still have 5.
5.
Yes.
From when?
From the Northwest.
Okay. But I mean, when did they start?
In 2022 early. Yes.
Right. And the reserve judgments you listed in this application form, are they still outstanding?
No, I don't have any reserve judgments.
Okay, they were delivered. Okay. You have also listed companies in which you hold directorships, but you undertake to resign if you are appointed.
Yes, Justice Ma, yes, I undertake. One of the companies, in fact, didn't. It was started in 2019, just before COVID, so nothing happened to it.
All right. No, thank you very much, Ms. Mahlangu.
Thank you.
I'll hand over to the other commissioners to put questions to you. JP Hendricks?
Thank you very much, TCJ. Good afternoon,
Good afternoon, JP.
Judge Mahlangu. How are you?
I'm okay, and you, JP?
Good, can't
Yes,
complain. Thank you.
yes.
Thanks for asking. You were interviewed in October last
Yes, I
year.
was here in October
Yeah.
last year.
And just to follow up on the TCJ's question, did you resign from the bar at one stage?
I at the Northwestern Polokwane Bar, yes.
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 When was that?
Last year, I think Northwest Bar, I think it was around July, if I'm not wrong, and Polokwane Bar, it was 2021,
Yeah, but are you currently a member of any bar?
of the Johannesburg Bar, yes.
Okay. Yes, thank you. I have a few questions that I want to canvass with you. There are comments from the law bodies. I think you are aware of it.
Yes, I'm aware of them, just JP.
Yeah, in particular from the GCB. Yeah. If you look at, I think you must have a copy
Yes, I do.
in front of you.
Yes.
If you look from paragraph 8.3 onwards, and any comments?
Regarding this matter here,
No, regarding the comments by the GCB.
I noted the comments and I went through them. I think they are unfortunate comments and they are defective. They are not, they do not stipulate what is correctly said in these matters.
Yeah.
I am of a view that, as they have stated at the end there, that I'm a correct candidate to be appointed, and the comment stated, if maybe I may start with the matter that is in 8.3, the matter of the matter mentioned there. I won't mention the name of the matter. Yes,
Yeah.
it was a defamation matter.
Okay.
Yes,
Yeah.
and in the plea of the defendant was replacing Mahlangu. There was a clip that was presented in court on the screen, and in that clip, the defendant clearly stated that they're all wearing the Mahlangu uniforms, they're all picketing, and then the first sentence he said was, I am here representing Mahlangu. I'm going to present whatever I'm presenting on behalf of Mahlangu. And the plaintiff during the trial did admit that indeed the defendant was not saying whatever he was saying in his personal capacity, but in his capacity as the chairperson or chairman of Mahlangu.
Yes.
Yes.
Yeah, if you go to 11.2, it states there that you display some hostility. You are hostile towards counsel. And 11.4, the temperament.
Yes, I saw this hostility that was said. Unfortunately, it is not clearly stated what is that, how was I hostile towards counsel.
Yeah.
Yes, and 11.4, the temper also, like I said last time that JP, I'm a very kind person. I don't see myself being temporal to the practitioners or any other person that appears in my court. I'm fully aware that I'm in court because of the people that appear before me. So I make sure that they all become comfortable and in presenting their cases. I don't know hostile, what do they mean by hostile? Maybe they're intimidated by my voice when I talk. I don't know. I don't understand what they mean by being hostile, but I cannot be hostile in a place where I'm put by the people. I'm there to serve them. So I cannot go there and be hostile towards them, as I am there for them.
Can I move to a different topic?
Yes, you
And
may.
that is with regard to the parted matters. You say there are still 5 parted matters outstanding.
Yes, yes, yes.
Yeah. You remember that in January there was an incident where you double booked yourself.
Yes, 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 yes.
There was a circuit court in Garankuwa which you arranged a date yourself. And then there was also for the very same week a circuit court in Klerksdorp.
Yes, yes.
Yeah, and we discussed that issue.
Yes.
How was it resolved?
Because I was in Garangua for a week, that matter was postponed. Then I went to Klerksdorp to attend to the one that is in Klerksdorp.
Yeah.
Yes.
And remember, I outlined to you the cost implications even for the state. It's not merely about the postponement of the matter, but there's cost implications.
Yes, yes, you did.
Yeah. And you are currently acting in the Free State Division.
Yes, yes, I am.
Yeah. We communicated and you also informed me that there is a criminal matter that you want to postpone because you are not available. And I asked why, because you arranged a date and you said you are going to act in the Free State. You remember?
Yes, yes, I remember.
Yeah, and then I told you, but the litigant, the accused, is going to suffer.
Yes, yes.
Yeah, and now did you arrange that?
And then, JP, if you can remember, you said I must come and do it.
Yes.
I did go, yes, I did come. I did went to Klerksdorp to do it.
Yeah, perhaps you can inform the Commission about the status of these 5 parted matters, seeing that you are now acting in the Free State.
Yes.
When are they going to be finalized?
I've all set them down during recess of June.
How many are criminal matters?
4.
4 criminal
Yes,
matters.
yes.
And the accused, are they in custody or not?
The accused are not in custody.
No.
Yes.
Yes.
And JP, if I may say, is the one in Klerksdorp, one of them, the accused are 14. So it's such a very big hurdle to deal with that matter, taking into consideration also the load shedding and everything. I've wished and wanted to finalize them during January as I came back from holiday or from the December holidays far earlier than any other person, so that I can be able to finalize them. Unfortunately, I could not. Even the one in Garankuwa is more than 5 accused, so it's not easy cases to deal with.
And all 5 of these cases are backlog cases now.
Yes, yes, yeah.
Yes.
The other one, the 5th one is at Hamahikeng. It's a civil one. It's 17 plaintiffs also. And it's the same challenge that I have. Each plaintiff has his own arresting officer, the witness. It's a very, very, very long trial also. So I understand that they are backlog, but it's not like where you have one accused person where you can be able to manage that trial. A trial where it's more than one party, it's very difficult to deal with promptly.
Yes, thank you, DCJ.
Thank you, JP. Premier?
Good afternoon, DCJ. Good afternoon, esteemed members of the JSC. I just want to have one question. If you look at the report of the GCB and you refer to 14.1, how do you reconcile 14.1 with 8.2?
Good morning, good afternoon, Premier. I take note of both 14.1 and 14.2, and I could not understand why in the same breath they say that I should be appointed and because I have the independent mind, and then in 8.2 they say I don't have enough professional experience as acting judge. If I calculate my acting stints, they go to more than a year and a half. So I don't know how long do they expect me to come act so that I can have this experience. I think I have enough experience that is needed and enough experience for me to be appointed in this.
That's all I had, Deputy Chief Justice.
Thank you, Premier.
Thank you.
Commissioner Nyambi?
Afternoon. Thank you, DCJ. Afternoon, Ms. Mahlangu.
Afternoon, Commissioner Nyambi.
As JP indicated that you were with us last October. So almost all of us here were able to have an opportunity to ask you some questions. It's some 5-6 months ago.
Yes, Commissioner.
So anything significant, because we do have the transcript of October, that you might want to share that might have happened between then and now, so that as this commission this time around we have to seriously consider?
Commissioner Nyambi, after the interviews of last year, I took it upon myself to train myself how to write judgments. And I read and went through the previous judgments of other judges. And I constantly discussed or asked the Deputy Judge President of the Northwest to give me some input and some more training on how I can approach judgments. And that is why when I was requested to come act in the Free State, I took the opportunity, taking into consideration that more training, I'll have more training from acting in that division. I therefore think that based on that, I'm ready, and I've gained more training based on the judgment writing.
My last question, if you reflect about the last interaction with this commission, probably if you can share with us, with hindsight, anything that you might have done when you were doing a reflection in a way that you might want to correct it this time around. I'm referring to the last interview of October.
Yes.
So you have an opportunity now to correct anything that you think might have made you to be at a disadvantage this time around, so that we can seriously consider.
Thank you, Commissioner Nyambi. I really don't know the reason why I was not taken last time, but what I can say is there was this matter that, as I said, I could not respond to it because it was on appeal that Commissioner Ngugaitobi asked me about it. And I did not answer to that because I said I don't feel comfortable in that matter. And what I can say is the appeal was finalized and my judgment was upheld. The appeal was dismissed in that matter. So I think I wouldn't really know, Commissioner Nyambi, what is the other thing that made me not to be recommended in the last interview.
No, DCJ, maybe if I can assist Ms. Mahlangu. The question was, you remember what you said last October. So the question was, the responses you gave us in October. So you are still of the view that everything that you responded to in October was fine as far as we are concerned, except the one of Advocate Ngoeto SC.
I think the other question was why you? Why should we consider you? That was asked in the last interview. And then now, if I can answer it now, is that based on the experience that I have, based on the acting stints that I had, and the judgments that I delivered in time, And out of all my judgments, I only received 3 leaves to appeal. 1 was not prosecuted, 2 were prosecuted, but the appeal were dismissed. And the other reason why I think I'm the right person for this position, Commissioner Yamba, I hope I'm still on the right track, was because of the unique experience that I have since I've started as a prosecutor until where I am now. And the other thing that I can say is the question that was asked, why do you think that you're the right candidate for this, is that I worked in the Northwest Province as a public prosecutor. I worked in the Northwest Province when I was working for Asset Forfeiture Unit based in Mafikeng. I was staying there in Mafikeng. So I'm of a view that Northwest Province is calling me to come and serve them now, again, until my retirement time.
Thank you, Ms. Mahlangu. Thank you, DCJ.
AP Person?
Thank you, DCJ. It's just a follow-up on the line of questioning by Commissioner Nyambi. Good afternoon, Advocate Mahlangu.
Good afternoon, Commissioner.
You have already confirmed that you were before this commission in October, and I take it that you were provided by the Secretariat with the transcript of your interview.
Yes, Commissioner, I was.
And what I want to put you as a general proposition is that reading that transcript doesn't inspire confidence in your competence for the position to which you aspire. What's your response to that?
It doesn't inspire confidence.
Yes.
As I've said, Commissioner, is that yes, I went through the transcript, and I noted when you say it doesn't inspire confidence, but where I am now, I think I'm confident enough to serve as compared to what I was in last year, October.
But you were here in October, the vacancies were advertised. Hardly 2 months thereafter, you made yourself available for a position in the Northwest.
Yes,
Again.
I'm sorry about to interrupt you. Commissioner, the reason why it made me to reapply is because last year no one was taken. So I thought, now let me use this opportunity again to come here and apply. And based on the experience that I might have got since I've been here in October, and the acting stints that I had, they might increase the experience that I had that the commissioners might need for me to be able to be appointed.
Thank you, Advocate Mahlangu.
Thank you.
Prof?
Thank you very much, DCJ. Good afternoon, Ms. Mahlangu.
Good afternoon.
I have a question for you in relation to the case that the judgment that you delivered. I think that's from page. Anyway, I'll get to it now. It is a judgment that dealt with the rescission of the agent application in relation to the Kagisano municipality. You remember that judgment? The municipal manager of the Kagisano municipality, whose contract was terminated. And
Oh, yes.
That judgment. Just that my computer is just frozen here. I'm always curious to understand how judges deal with urgent applications. In Gauteng, for instance, there is a judgment that really assists in understanding Rule 612 of the Uniform Rules of Court, and that judgment guides us as to if you want to be successful with urgent applications, what you need to comply with. And it sets out quite clearly what needs to be done. It explains what needs to be done. I'm not sure in the context of the Northwest Division, we have that kind of judgment. And looking at your judgment, I just want to understand from you, what is the test for agency? And what do litigants who want relief on an urgent basis need to comply with in order to fulfill what is stated in Rule 6, Sub-Rule 12, in that jurisdiction? I just want you to get that understanding, because when I look at your judgment, you cite the rule and you revert back to the facts of the case, not necessarily the actual agency, and you proceed to determine that the matter is not urgent. So I just want to understand, in the context of the Northwest, I know that now you are at the Free State, but because this judgment, you were sitting in Mafikeng, I just want to understand what is the test for agency and what needs to be complied with for one to be successful when he or she has brought an urgent application.
I think the test for agency applies in all the divisions. It's not specifically for Gauteng, Northwest, or wherever. In all divisions, the test for agency applies. So in an urgent application, the first thing that the applicant must prove is agency, to prove that that matter indeed there's agency in that matter, and an order must be granted as soon as possible, as there might be some injury that the applicant might find himself or herself in. So there's no specific test for a specific division.
No, that's not the proposition that I'm putting to you. Uniform rules of court applies to the High Court and therefore to all the divisions of the High Court. That I'm fine with it. But each and every division, there will be a certain approach or a certain attitude to certain applications because of the frequency with which those kinds of applications are brought and how perhaps the practitioners in that division treat those kind of applications. So I know that when I bring an urgent application in Gauteng, there is a case, East Rock Trading, that outlines what I need to do. And when I do exactly that, I know I'll be fine. But when I look at your judgment, it doesn't deal with Rule 6.12. It just set it out, but it doesn't really deal with it for one to understand in the context of that case whether the matter was urgent or not, and if it was not urgent, why that matter was not urgent. As I was asking you about the test for agency.
I'm not aware of any special test for agency in the Northwest Province.
Okay, no, it's fine. I will leave it there. Thank you very much.
Rudolph?
Thank you very much, Acting CJ. Advocate Mahlangu, I can see that this time around you are better than last time. Your composure, your demeanor is much better. And I remember you were unsettled by the question that Advocate Nkaitobi asked you. I wish that this time around he asked you again a question. I want to see how will you behave.
Thank you for that, Commissioner.
Yes, now.
But I hope Commissioner Nkaitobi doesn't unsettle me.
I want to ask you about the case of 2001, and I want to test your understanding.
Is it one of my cases, Commissioner?
No, it's not your case.
Okay.
It is the Lubaka case that deals with Section 174 of the Criminal Procedures Act, where an accused is discharged at the end of the state case. And my take is around the issue of presumption. And there's been a lot of discussion in the public domain about that case and whether the provision of Section 174 is it still relevant or not? And I want to get your understanding. In your view, do you think that that provision must be abolished or not? And what is your take on that?
You mean the 174, section 174 should be
174, yeah.
abolished? I don't think that it should be abolished. I think the accused persons have the constitutional rights in court as much as the state that is presenting the case, because it will be a fruitless exercise if the judge or the presiding officer presides on the matter where he could see, or he or she could see that the accused person, there's no prima facie case against the accused person. So once that application is brought, I think it's up to the accused to bring it or not, because it's not a mere thing that the court
But
can
with my
decide on.
limited legal knowledge and understanding, that provision gives a presiding officer or a judge a discretion, and don't you think that that is problematic in that respect?
No, I don't think that is problematic. Like I said, the accused person has a right. If once I can see that the state could not prove his case beyond reasonable doubt, then the accused person can bring that application. And as you have rightly said, that is the discretion of the court whether to grant it or not.
All right, thank you very much. Thank you.
Follow up, CJ. Ms. Mahlangu, I just want to understand. Are you saying that the test for 174 discharge, at that stage, the state has to prove its case beyond a reasonable doubt? Is that your submission?
My submission is that there's no prima facie case against the accused
Yes.
person, yes.
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 Thank you very much, DCJ. Good afternoon, Ms. Mahlangu.
Good afternoon, JP.
My question relates to what you've listed in paragraph 9.6 of your questionnaire.
Let me go to it, JP.
I'm on the electronic version, so I don't know what the page number is on the physical version. But the question relates to the 9 part-head matters that you've reflected there, and it sort of worried me. I've never come across a judge having more than one, probably 2 part-head matters. I know this is norm in the regional court. Are these high court matters?
Yes, JP, there were high court matters. If I may just a little
Yes.
tell how did it come that I have those part-head matters. Those part-head matters, most of them, if I think 1 or 2 were in the High Court Mafikeng, they were in the circuit courts. And in the circuit courts, there's no backup once this load shedding. At some stage, we had 4-hour load shedding, and you start a trial. Unfortunately, you cannot be able to finalize it. It becomes better if load shedding starts at 12, at least you can start the court at 8 and try to push as much as you can so that you can finalize those matters. But unfortunately, the predicament I found myself in the circuit courts, there's nothing much that you can do. Like, for example, at Garankuwa Circuit Court, there's a generator, but the generator doesn't operate the recording machines. At Rexdorp, there's no generator. Once it is load shedding, the court becomes so dark that everyone leaves the building. So unfortunately, because of that, JP, I couldn't. If you can see those, I've started to act in 2020, but most of those part heads are 2022 when load shedding started to be severe in the country.
Okay. Thank you very much for that, because I was really worried. I remain worried because the High Courts run a running roll system,
Yes.
which is intended to make sure you don't take new work when you still have old work unfinished, isn't it?
Yes, like I said, it's circuit courts, and circuit court is beyond our control.
Yeah.
It's
But
something
are they
else.
still all outstanding, the 9?
No, JP. I managed to finalize 4. It's only 5 now that are still outstanding.
Okay, last question, DCJ. The 2 reserve judgments you mentioned there, that were reserved in October last year, were they handed down?
They were handed down, yes, JP.
When?
We closed, I think around November. Yes,
Okay.
yes,
Around November.
yes. We
But
closed-
when did you file your application? Didn't you file it in November?
Yes, I think 2 weeks after I filed JP, because one of them was a full court judgment. Yes.
Thank you, DCJ.
DM?
No, just as a follow-up to JP Mlambo, he asked you, sorry, good afternoon. He asked you about the 9 part herds, and you blamed the circuit courts. But of the 9, 5 of them are Mafeking.
Good afternoon, Commissioner. Yes, I said yes, earlier that most of them are in the circuit courts.
So with respect, 5 out of 9 is the majority, that is Mafeking.
Those are the ones that are managed to finalize, yes.
I'm sorry, I'm not getting you.
Yes, I said.
Five out of 9 are from Mafeking. You complained about Garankuwa, that's 1. And then you complained about Klerksdorp, which is 3. So most are from Mafeking, but you're saying the problem is the circuit courts. But what's the problem with Mafeking where there is a generator?
Commissioner, if I may say, the Northwest Division, the role is not like the Gauteng one, wherein you have a running trial for 2 weeks or 3 weeks. So the ones that we do also pick up part heads in Mafeking because of that's how the role is structured. So I did have the part heads also in Mafeking that I postponed, then that I managed also to finalize.
Okay, so you're saying what you said to Judge JP Mlambo is incorrect?
No, it's not incorrect. I said most of them are in the circuit courts. And
Most
that's
of
where-
them are in Mafeking. Anyway, I'll drop it. Thank you.
Yes.
Any further questions for this candidate, colleagues? Oh, sorry, I forgot you, Prof. Advocate Steinberg. It's late.
Good afternoon, Ms. Mahlangu.
Good afternoon, Commissioner.
Just to disclose, we were shared chambers some time ago, so we know each other from practice.
Yes.
I noticed that in the GCB's review, they talk about a judgment, Tselapedi versus Lawu, a defamation action.
Yes.
And unfortunately, I couldn't find it online. But what I read from what the GCB has said is that you granted absolution from the instance. The defendant had, in his plea, had admitted that he had made the statement on TV. So I want to understand, firstly, do you still stand by that judgment? And on what basis did you make that finding?
Yes, if I may, just as I've said earlier, I even referred to the matter of EFF versus Trevor Manuel.
Yeah.
In this matter, the plaintiff says the defendant uttered this weight, and the defendant, according to the plaintiff, she assumed that she was referring to her. And then in court, there was a clip, the TV clip that was brought in court. The defendant said in that clip, wearing the Nehau uniform, having placards in front of the building of the municipality, or wherever building, I just forgot which building was that. And then the defendant uttered the words and says, I'm here on behalf of Nehau. I'm going to speak on behalf of Nehau as a chairperson. And the plaintiff during the trial considered that, yes, that's what the defendant said. The defendant said he was speaking on behalf of Nehau. So then the defendant could not be held liable for what was said on behalf of Nehau and not on his personal capacity. And then what I was opinion of Commissioner was that the defendants on that day having placards, they could not have simultaneously spoken to that TV journalist. That is why the chairperson was allowed to speak on their behalf.
Now, I did hear you say that earlier, but I wanted to understand that. My understanding of the law of defamation is that if the plaintiff establishes that the defamatory words were published and were about him or her, then the plaintiff has established defamation.
Yeah,
And then the onus shifts.
Yes, if I may go further, is in that television clip, the name of the plaintiff was not attached. The defendant was generalizing, saying the employees of this department, all of them gave themselves the increment of 51%, and therefore they should all be suspended pending the investigation. And the plaintiff in court considered that, yes, I only became aware that my salary was increased after I saw that television clip. I was not aware that my salary was increased, and I made arrangement to prepay whatever was paid to me. So the name of the plaintiff was not mentioned. That is why I said I referred to this matter wherein the name of the person was mentioned in TV, on television, that such and such a person did 1, 2, 3. So in this matter, the plaintiff's name was never uttered.
But we know that a plaintiff's name doesn't need to be mentioned for the plaintiff to be identifiable. So can you tell me the reasons you gave in your judgment for granting absolution? You don't recall?
I can recall, yes.
Okay, then I'll leave it at that.
Could I make just a short follow-up, not to Commissioner Steinberg, but to Commissioner Marumo Achai? I'm not asking you a question this time, Judge. I'm just trying to help you to make sure you've answered the question that's already been asked. Rule 612B, you remember the question you were asked about agency?
Yes.
Contains 2 requirements for agency. You were asked to explain, I think the word that was used is the test, but let me just try to simplify because I'm sure you know the answer. What are the 2 requirements for agency under Rule 612B?
Interdict. The applicant must prove that the matter is urgent.
But the point is, what should the applicant say to prove the matter is urgent?
I can't think of it on my feet now, Commissioner.
Thank you, DCJ.
Other questions from the virtual platform?
Maybe just one, DCJ.
Yes, Commissioner Bernard.
Thank you. Good afternoon, Advocate Mahlangu. When should a judge recuse herself from hearing in a matter?
Good afternoon, Commissioner. The main test for recusal is biasness. Once the judge becomes biased to the matter, for example, the judge becomes interested in the matter or in the judgment, or maybe the judge is familiar with the facts, for example, knows one of the parties, then the judge must recuse himself from the matter.
Thank you very much. Thank you, DCJ.
Yes, Commissioner Bernard. AP Peter.
Thank you, DCJ. Advocate Mahlangu, I want to take you to paragraph 6.3 of the feedback from the GCB. Which states that the concerns that were noted during your October 2022 interview still persist.
6 point what, come again, Chair?
6.3.
3. Oh, yes, yes.
Do you have a response to
That? Yes, JP, I can see. When I think this matter was relating to quantum, as you can see in paragraph 1, 2, 3, 4, 5. They say the candidate is criticized for not considering constitutional rights of plaintiff in unlawful arrest matters that have said before her when assessing appropriate award. In quantum matters, I normally do not deal with the constitutional rights. I deal with them in a merit. In quantum, I cite the previous cases wherein the awards are dealt with, and then I base the award that I'm giving to the particular plaintiff based on the previous cases that I'm going through. But I don't think that this concern is not correct. I cannot repeat what I was told I was not doing in the previous interviews, Commissioner.
Thank you. Then we proceed next to paragraph 6.4. Where an application was moved before you for substituted service, which you granted.
JP, thank you again for this question. I went through paragraph 6.4, but unfortunately, because there are not enough facts here of how did this happen, I couldn't think of the case that I did relating to this. If I can say this, JP, that I've done many unopposed matters in the Northwest, and I really do not remember making such a mistake, but indeed, if indeed I did this mistake, I would expect the practitioner can bring it to my attention to make a rescission so that this order can be rescinded. But I cannot remember which matter is this. I've done more than, I think, 1,000 unopposed matters in my stay in the Northwest Province.
But what I find troublesome is the fact that you granted an order for substituted service, and immediately thereafter, the legal representative for the plaintiff seeks default judgment, which you grant, telling you that we have already served this summons by SMS. So in effect, you granted default judgment even before there was service of the process on the defendant, shutting the door of the court to the defendant.
Yes, as I've said, Commissioner, that I cannot remember this matter, so therefore I can't say what happened on this matter exactly.
Did you take the trouble to investigate?
Unfortunately, also there's no case number. I didn't know how to approach it. If maybe there was a case number, I could have maybe seek the record or something to check what happened on this day. But I'm very thorough in my unopposed matters. I don't believe that I can make such a mistake, but should it be brought in my attention, I will.
Did it not occur to you, your counsel yourself, to approach the GCB? Could you please provide me with details of this matter so that I can prepare for the upcoming interview in April and be in a position to deal with what you have raised in that paragraph?
Okay. I did not think of doing that, Commissioner.
Thank you. Thank you, DCJ.
Commissioner Matolo Lepu.
Thank you, Deputy Chief Justice. Good afternoon.
Good afternoon, Commissioner.
You know, I'm looking at the comments from the Law Society of South Africa. I just wanted to confirm, especially on the last paragraph. Do you have the
Yes, I have it, Commissioner.
I mean, the comment says, due to the the issues that were raised in October 2022 by several commissioners, it appears that the applicant needs to gain more experience in civil litigation to overcome the shortcomings, and as such, they're not supporting you. But do you think that's fair?
I
Or-
don't think that is fair, Commissioner. I'm of a view that I have enough civil experience. And like, if I can mention that my practice was civil litigation. My practice was trial court. So, and also most of my judgments are, in fact, not all, yeah, most of my judgments are civil trials. So I don't, this comment is very defective, Commissioner.
Okay, thank you.
The title of the head of court of the Supreme Court of Appeal is President. A person who acts in that position is acting president, not JP. So
Oh, yes.
Commissioner Betze next to me is acting president Betze, not JP Betze.
Oh, my apologies, President Betze. Yes. I
All
hope
right.
my apology is going to be accepted.
Yeah.
Yes.
Well, we have finished interviewing you, Ms. Mahlangu. Thank you so much for taking the time to come here and subjecting yourself to all these questions.
Yeah,
but
thank you.
your torture is over.
Thank you. Thank you very much, everyone, for giving me time to be interviewed again.
You're
Thank you.
excused.
Thank you.